Thank you. You may be seated. Good morning. We're here today in the matter of State of Arizona versus Rafael Morris. Our case number 1CA-CR240376. Each side will have 20 minutes. Counsel for appellant, if you want to reserve time, you'll need to watch the clock to save whatever time you'd like for rebuttal. We have conferenced this matter. We've read the briefs. From my perspective, the briefing was well done on both sides. We appreciate your efforts with the briefing. These proceedings are being recorded, both audio and video. It's helpful for the audio recording if you'll identify yourself when you begin your argument. And with that, counsel, you may begin.
Please, the court, counsel, good morning. It's a privilege to be here today. My name is Thomas Alonji. I represent the defendant, Mr. Rafael Morris. I would like to, I don't know if I can announce reserving 5 minutes, but that's my goal today. I also understand that the court may have questions regarding issues that I don't plan to bring up. It's a 2-issue appeal, and I know that our second issue had to do with the sufficiency of the bribery conviction. Unless you direct me differently, I believe that we've made our point for Rafael, both in the opening brief and the reply. Today, again, unless you tell me differently, I'm going to focus on the jury selection issue. And I do want the court, and I want to commend counsel for professionalism throughout all of this. The communication's been really good, and we talked a little bit about the Puga matter. We are familiar with it, and I will touch on that briefly also when I'm done. For the purpose of this oral argument and to avoid rehashing what I've already written, I really just want to highlight first the basic rules that we understand to be in play given the argument we've raised here today. We know this much from Criminal Rule 18, that the court must ask any necessary questions about a jury candidate's qualifications. That's Rule 18E. We know, number 2, that the court must thoroughly examine prospective jurors under Rule 18.5 sub F. We know that the court must consider the totality of a panelist's conduct and answers, Rule 18.4 sub H. We know that the court is required to control the voir dire process, 18.5 F. We know that the court is encouraged and supposed to use open-ended questions that encourage a narrative. I'm going to emphasize that one when I get going here. And that, of course, is in the comment to Rule 18.5F. The court, as a twin to that, is supposed to refrain from asking conclusory questions that generally encourage the juror to simply affirm, yes, I can be fair. And then last, the court is required to strike a juror in the presence of any reasonable ground. I think the article in the rule is the word a reasonable ground. The juror must be struck. It is not discretionary, it is required. So that's the backdrop in Rule 18. Number 2, we know from the Attorney General's own brief in the State versus Colorado case that historically, even well before the changes in 2022, that we have to have jurors who are not encumbered by any circumstance that would hinder their entire impartiality. And the air quotes is for the phrase, entire impartiality. That is from State v. Colorado. The Pacific Reporter was the only one I could find with this page site. That's it, Pacific Reporter, 535, page 944, paragraph number 13. And that takes me to the juror who was retained. Use the initials, of course. Her initials were CM. The juror that was retained by the trial court over my predecessor's objection. When you look at the sequence of events, this begins on really page 23 of the jury selection transcript. The court appropriately asked the entire panel, after identifying what the charges were, whether there was anyone on the panel who might have issues, might be tend to favor one party or the other. So when that question was asked, the entire panel knew that it was a cocaine and fentanyl trafficking charge and a bribery allegation. The reason I emphasize that here is because the waffling, if you will, that the state attributed to a different juror who was struck by the court is actually sort of waffling that happened here. If you look carefully at page 23, there was only one juror who raised their hand when the judge asked, would the nature of these charges cause any favoritism? Only one raised their hand, significantly not CM. So her baseline, if you will, is she is by omission telling the court, I have no issues regarding these charges, which we will know later on is not true when she was questioned about it. But for the moment, page 23, there's nothing from CM. And then pages 26 and 27 of the transcript, the court gets into the business about family members or close friends. At that point, CM candidly raises her hand. She points out that she got that going on. And the excerpt that I'm really going to exclusively focus on, unless you ask me differently, begins on page 27 of the transcript, line 19, continuing to the next page all the way down to line 25. It ends the page. That is significant not just for what it says, but how it was said and how interruptions occurred during that dialogue. You look there, the juror says, my sister, she deals drugs. She's been in trouble for that. The court says, you say she deals it. Do you believe she's still involved in that? And the juror says, I don't talk to her. I have no idea what she's doing now. So far, so good. The court says, is there anything about the fact that your sister is involved in that may cause you to favor either side? She says, I'm not sure. I know that these trials are replete with pivotal moments, okay? That was a pivotal moment because that was the only point from that point forward where that juror had not committed yet.
Are you saying the questioning has to stop at that point? Or?
No, not at all. Okay. I interrupted you.
No, I'm just curious.
No.
What then happened that
Right.
that you're suggesting was
right.
improper?
And that's why I mentioned all these different parts, because I think they all fit together. We know that the court has to do questioning, has to, otherwise they're violating the flip side of the rule. But we also know that they are supposed to investigate thoroughly. Investigate may be the wrong word, but they're supposed to thoroughly examine to get to the bottom of this, to ask any necessary question, which is the text of the rule. That would have been the moment for the court to say, why aren't you sure? What's going on? We don't want to embarrass you. If you'd rather talk sidebar in private, which is what happened in the Puga case. Okay, is there something about this that is tearing you up, that makes you think maybe I can be fair, maybe I can't? The court doesn't do that. The court, for a moment, goes in the right direction and says, do you believe that her involvement may affect your ability to be fair and impartial? And look at the juror's answer. She doesn't answer the question. She says, what she does, I don't condone it at all. That is not what she was asked. No problem with the idea that she doesn't condone her sister's behavior, but she didn't answer the court's question. And then instead of the court saying, I appreciate that, this must be painful, embarrassing for you. No one likes to talk about family, but talk to me here. Why the hesitation? Why do you think you might not be able to be fair? But at that point, the court asked exactly the question they're not supposed to ask, which is, hey, despite this, do you think you can still be fair and impartial? That is guiding her toward the answer, sure, I can be impartial.
Counsel, let me ask a few questions as to that point. Mr. Morris's counsel made no objection to that question or any other questioning by the court, correct?
Correct.
Mr. Morris's counsel had a full and fair opportunity to ask additional questions of the jury, correct?
True.
All that's required by the rule, and I read the transcript and the briefs the same way that your answers respond. And there is a comment, as you point out, on 18F with respect to how voir dire examination should occur, that says what the court should and really should not do.
Yes, sir.
And your argument is that that happened here and it should not have, even though there were no objections and no follow-up by your predecessor.
Correct.
And we are here on an abuse of discretion standard of review. Do you agree?
Yes. I think we may disagree about what abuse of discretion we're describing, but that is the standard.
Well, and that's why I wanted us to talk about that a little bit, because I read your brief as kind of suggesting that when preemptories went away, somehow the standard of review should be different. And I want to better understand, if that's your argument, better understand that argument.
I may not have said it as artfully as hearing you ask the question, maybe I would have. I'll put it this way. We are not saying that the judge erred by misweighing the credibility of that juror. Puga's all over that, and so a whole bunch of other cases too. We wouldn't be having this conversation if that was the argument. The problem here is that the abuses of discretion include errors of law. And our position is that the court, at once and the same time, not only failed to do the proper follow-up questioning, which was a legal error, but then failed to strike the juror when it should have been clear that there was a reasonable basis to believe that she might not be impartial.
Well,
that would be the abuse.
And we're talking about CM again here, right? Not AC yet. We'll get to AC, I assume. But didn't CM say, hey, at the end of the day, I can be fair?
She did.
Under oath,
She did.
in response to questioning by the court,
She did.
where there was no follow-up from your predecessor.
Agreed. And I will answer both those thoughts. I was going there next anyway. Here's the problem. Once she committed, once the judge asked the question, do you think you can still be impartial? You have to remember her backdrop. It's not just any jurors, hers. This is someone who, she's standing in a public courtroom, in front of a Superior Court judge, under oath, in front of strangers. She eventually gets, I have a brother-in-law and a cousin, sheriff and chief of police, friends, family who work in the court system in like that same county. This is someone who, even more than the average juror, is going to want to appear to be fair because she knows what her family's about, what she stands for. But even beyond that, she, like anyone else, is not going to want to admit that they made a mistake and backpedal. We do it in our buying decisions.
What mistake are you saying that juror made?
By saying she interrupted the judge. She was so anxious to say, I can be fair, that she cut the judge off before he finished the question and said, I can be fair. She was embarrassed. She had just been asked to talk about a family situation.
Does that, and I know I'm interrupting you, but I also know our time is going fast, but does that mean that the court was required to disbelieve juror CM? In other words, saying, I don't think you're telling me the truth, even though you're under oath?
No, that would have been the moment for the court to recognize he didn't answer my last question. Maybe not to say it this way to her face, but to say to himself, she didn't answer my last question. She deflected it. She cut me off as if to reassure everyone, I'm not my sister. I'm different. I can be fair. A very human reaction, but again, not the relevant question. But once she committed to that, the court's error was not that it chose to believe her. The court's error was that once he had cemented her saying what she said by asking a question that really should not have been asked, he made it almost impossible for either himself, and especially just a lawyer later on, to try to get that juror to admit, you know what, I take it back, maybe I can't be fair. And that's good.
But doesn't, no, go ahead.
So the question you take issue with that you think was incorrect was, quote, do you think you can be fair and impartial?
In tandem with where and when that question was asked, and the fact that the juror had deflected his last question, which might have unearthed more about why she couldn't avow that she could be unbiased.
Was that when she said, I'm not sure?
Her opening response was, I'm not sure.
Okay, but that was in response to that may cause you to favor either side. And it's not clear. I mean, someone who has a family member with a drug problem may not want that family member to be sentenced to prison for 50 years. It doesn't necessarily equate to, I'm going to come down hard on the side of the state. And the question is, would you favor either side? I'm not sure. Doesn't that require some follow-up by the court? Do you believe that her involvement that may affect your ability to be fair and impartial. Why isn't that a fair game for the court to ask?
Because in the context in which it's asked, he's basically asking the juror to either announce publicly, I can't be fair, or he's asking her to commit to being fair when maybe she's not quite ready to do that. And the court didn't recognize by asking her that question with what the dynamic was. It was her own sister engaged in fentanyl. The error was that the court didn't recognize this is super sensitive. It involves her own sister. She's not even talking to women anymore. She's clearly embarrassed. I need to have a conversation. Can you tell us why you're unsure? Tell us your uncertainty, because if it's nothing, no problem. Serving the juror, we'd love to have you here. And if that has to be a sidebar or have the hearing of the other panelists, then that's fine. You do it that way. But it's how we jump to the question. And I don't know if it's quite as leading as a judge saying, well, you can be fair, can't you? Which would obviously be leading, but it's darn close to that.
Well, but there was no request by any of the parties. The court did not say, we're going to talk to you privately outside the presence of the others. That's clear. But the parties didn't ask for that either.
Agreed.
And I get the thought that a courtroom is an unnatural environment. Let me use that term, especially for jurors who've never perhaps been to a courtroom. But that's true for every juror in every courtroom where a voir dire is conducted.
It is, and I think the problem though is that once the judge decided to ask her, "Can you be fair?" and she cuts him off before he even finishes the question, he's kind of locked her into that answer. So if you're asking me, do I wish defense counsel had asked for sidebar? Of course. Do I wish she had followed up this with her own questions later? Of course. But I'm concerned, unsettled, if you will, at the thought that with all of this having now been consolidated into the trial judge, peremptory strikes are gone now. Because this would have been easy with peremptory strikes. You just listen to her talk, maybe ask a couple questions, and then strike the person later. It's no longer an option. So with all of this responsibility and power and directives about the court should do this, must do this, can't do this, a situation like this, which does make it different from Fuga, where the judge asks a question that is a yes or no question. It may not be blatantly leading, but it was only a yes or no. Will this affect you? Once she says yes, what really can the defense lawyer do? Fuga speaks in terms of, oh, you have to make a real-time objection. Well, that's well and good when you're objecting to a colleague. But I don't know too many judges who would say, objection, Your Honor, your question's inappropriate.
Counsel, I understand that. Now, at some point, that's what the rules require. But let me give you an alternative. Mr. Morris's counsel could have asked to question that juror privately and to push and nudge. And I think 18.5F sort of gives an open door for that. None of that happened here.
It does, but I don't know that that should be required. Would I like to see it? Yes. It's the better practice. And maybe if the sequence of questioning had happened differently. So let's say, to answer your question the rest of the way, let's say hypothetically she had said, I'm not sure. Number two, what the court asked, how do you feel about this? And she's like, well, she is what she is. I don't have the exact words memorized, but okay. And then if the court says, or defense counsel or anyone, if the court says, well, let's talk about this. If defense counsel of the state says, Your Honor, how about if we do this sidebar? That's fine. If the court develops it by getting into the narrative that is encouraged and envisioned by the Supreme Court, I could see a moment where people might say, boy, this has got to be really hard on her. Let's bring her into a different room. But once the court, I'm not sure there's really an opportunity for anyone to say, hang on, Judge, time out. You're getting into whether she can be fair and impartial. I don't know that that's...
You don't read 18.5F as counsel having the opportunity to at least request to follow up with additional questions, perhaps do that outside the presence of the others? I do read it that way.
I'm not saying that at all. I agree with you, but I think once she had committed publicly to a judge that she could be fair, I think it's a big ask for a juror, even in private, out of the hearing of the others, because the judge is still there. And if she's in that room with the judge and the lawyer, and she just got done telling that judge not 5 minutes ago, yeah, I can be fair, no worries, and now she's being, probed by this defense lawyer who begs to differ, I still think that is a big ask to get a juror to come back from where they were and admit, you know, maybe I wasn't being truthful about this after all.
And I understand that, but if that carries the day, if that point of view carries the day, that the open court is coercive, and that, you know, sidebar or outside the presence of the others is coercive, how does jury selection ever work?
Because it's not just that the option of the sidebar was there or the option of coming back to chambers. It was the fact that the court, by the point where that kind of request could have been made, the court had already induced her with the yes or no question to say, can you be fair and impartial? And once she said yes, that makes it a lot more difficult, and I would argue illegal and unfair, to ask the defense to try to remedy that damage.
And I understand, but another way to look at that is the juror thought under oath she could be fair and impartial.
Then why say from the beginning? I'm unsure. I guess I'll answer the question with a question of my own. Where in those brief 7 lines did either the judge ask or she answer in a way that it would satisfy you as the reader that there was some legitimate reason for why she was no longer uncertain? Because it's not there.
But they're different questions, though, as Judge Catani pointed out. And the first question is, at least from the record, and that the court could fairly conclude during voir dire, is ambiguous as to which side, if any, the prospective juror would be inclined to support. And then more questions followed.
But the more questions should have come before the judge asked what I would call the hammer question. If the judge were to ask 5 or 6 follow-up questions.
Which was the hammer question?
The one where the judge says, okay, let me ask you, page 27, line 12.
Is it?
She just got done deflecting the question about.
Is it if you were called to serve on a jury where those are the charges, would that
Yes.
in any way affect how you
Yeah.
view the evidence?
Exactly. And then she stops him and says, I can be fair.
But, yeah, okay. And we've taken up your time. Maybe if it's okay with my colleagues,
Probably considered it.
we'll
That's
give you an extra 2 minutes for rebuttal.
I appreciate that.
And
Thank you.
and counsel for the state, if you need more time, you can have it.
Good morning, may it please the court, Christine Davis from the Attorney General's Office for the Appellate State. I'm going to sort of dispense with my script and just go straight to the heart of the question that, you know, based on Appellant's argument and really kind of getting at what that juror may have been thinking when she said, I'm not sure. I mean, we're in a position to speculate about that, but as long as we're speculating, I'd like to add my 2 cents. And in terms of how the court frames that issue and what the trial court was supposed to do with that. I think we have to remember that when civilians enter a courtroom for jury selection, oftentimes for the first time, that can be a really, as Judge Thomas said, a unnatural environment. It can be intimidating. And oftentimes they're asked questions that they've never contemplated before in terms of, you know, it's very personal too, in terms of whether they can be fair, and whether they're biased, and whether there's something in their life that may cause them to prejudge the case at hand. And so it's not at all uncommon, it's actually quite common for jurors to sort of hedge and maybe buy a little time by making comments like, I'm not sure. So they can really reflect, it's a very human tendency to sort of want to reflect on what specifically is being asked. So I don't read a lot into, I'm not sure, if, especially to a question of could this cause you to be unfair to either side. I think that happens all the time, and it puts the trial court sort of in a position then to do under what I think exactly what's supposed to happen here in the Rule 18.4 is to then follow up. Okay, well, you know, I'm trying to get at what is it that you're not sure about? Is it, you know, your sister's involvement? And so I think the trial court's questions were appropriate under Rule 18.4 and prior decisional law, which we know from Colorado and Montoya and Fuga is still valid in terms of the standards and the discretion. And then we know from those cases that that a comment to Rule 18.f, an advisory comment, didn't strip any discretion from the trial court in terms of how it manages voir dire. So I want to offer that to the court in terms of how we, you know, resolve this kind of I'm not sure, and then her rolling into, you know what, I think I'm okay with this. And then every question and every answer that came after that was consistent.
What is the force of the second sentence of the comment to Rule 18.5F, and let me read it more for my sake than yours, but the court should refrain from attempting to rehabilitate prospective jurors by asking leading conclusory questions that encourage prospective jurors to affirm that they can set aside their opinions and neutrally apply the law.
In terms of the force, I would say that it's a rule comment, so I think it's advisory, and I think it's offering the court a best practice. I think in terms of our analysis here, it certainly does set up an argument for, did this reach a point? It's really a question in every one of these cases, a very difficult question about what is proper clarification versus what is improper rehabilitation.
Right.
And that's very fact sensitive, and it's something, with the abolition of peremptories and that addition of the rule comment that we're going to have to look at in each case. In terms of the force, I think it's advisory, it's best practice, but it does go to the abuse of discretion.
It's advisory if it's a leading question. You can be fair, can't you? Would we just look the other way and say, that's just an advisory comment? You can be fair, notwithstanding your sister's involvement.
I think that is technically a leading question if we were in a trial and we were going to make an objection, sure it's a leading question, but I think what the comment is really getting more at is the court using sort of the weight of authority in the courtroom to borrow counsel's phrase, to induce or influence a juror. And I think those are the kinds of leading questions that we wouldn't want to see here. So I'll give an example. I think if the court here had said, well, the fact that your sister deals drugs, that's not going to influence you here, is it? Or, something that would perhaps cause embarrassment or shame.
Well, isn't that, the court did exactly that. Her involvement in that wouldn't affect your ability to be fair and impartial in this case? Would it affect your ability to be fair and impartial? You're saying if you'd said it will or it won't, it's the leading.
I think phrasing matters when we're, again, dealing with civilians who are in kind of an uncomfort, they're in public and they're talking about something very personal. And when I read the colloquy here, the multiple questions in context, I don't think the judge here was, and again, this is factually sensitive that we have to evaluate. It's difficult, but was the judge after a certain answer? I think is a fair standard to apply. Was the judge trying to coerce this juror to say she could be fair and keep her seated? And I don't read the colloquy that way.
Counsel, I don't remember at the beginning of jury selection, but if either of you do, did the court say, hey, if you wish to speak to the court outside the presence of the others, that's an option? Did that happen or not?
And I'm happy to let counsel jump in.
Well, and I should know, and I
think
don't.
That, often is the standard part
Right.
of the script, but I can't answer in this
It,
moment.
I'll find it. There is an answer to that, but I'll find it. Yep.
I also, in terms of distinguishing both, we should talk about Dobbins, the special concurrence in Dobbins, and the dissent of Hugo and the position that's being advanced by a minority. Judge Jacobs is advancing that position. I think Hugo is pending a petition for review. The Arizona Supreme Court. So this is something that's being looked at. But I think there's a real difference here factually between seating a juror who is a victim of a sexual assault, an actual historic crime victim in a sexual assault case, in a sex crimes matter. And in one of those cases, I think this Hugo, there was actually some evidence in the record that the prospective juror had teared up or her eyes appeared to be wet, so there was a real emotional response. I think that's very different than CM here, who is talking about an estranged sister. It's personal to a certain extent, but she's sure disavowed any real connection. Like, I don't talk to her, what she does is hers.
But you're not going to push for a hard and fast rule that someone who's been a victim of a crime can't sit on a jury. And it seems like someone who has very strong feelings, has had very traumatic experience with a family member, would be in very much the same position as the victim at different degrees. But I'm not sure that it seems to me it's the level of certainty that's more at issue about whether that person can be fair as opposed to whatever the particular circumstances was.
I agree, Judge, and certainly we're not going to, here concede prior decisional law that a victim of a crime can't serve on a jury. I guess what I'm suggesting is in terms of the follow-up that might be required from a trial judge, in terms of it triggering some real concern. And he did follow up here and said, what's the relationship with your sister? What about that could be a problem here? And the juror said, well, what she does, the judge's next response, the next actions required of the trial judge under the rule. We didn't, I guess I just would like to say that I think based on this record here, I don't think we see any improper rehabilitation happening with CM. We don't have a challenge here to the court's dismissal of AC. There's no challenge, really, that was just raised to sort of encourage this court to engage in some comparative analysis in terms of what the trial judge was doing with what here that day and what the trial judge was thinking.
Well, and the court used that as an example of this was different than this one.
That's right. That's right. And I think that that's very reasonable under the circumstances. I mean, there's a real difference between I'm not sure in response to, would this cause you to be unfair to either side, and an open statement of, I guess I'll say I'm biased. And then, upon follow-up question, and here the parties did engage in some follow-up question with AC, and he said, I can be fair, he did say that multiple times, but he also said, I guess it would stay in the back of my mind. And we have a credibility determination made by the judge on the record that he found AC to be fickle. He used that word. And of course, this court, we're looking at a cold record, which is why tremendous deference is given to the trial court in terms of making credibility determinations. When listening to jurors' answers and seeing how they respond and just kind of picking up on the tone generally of the court.
Counsel, let me ask you sort of a 50,000-foot question. The rule changes, the cluster of rule changes that were put in place when peremptory challenges were eliminated in Arizona, how did those affect what should happen during voir dire?
Right. So I think I'm going to differ with my friend in terms of whether that was a sea change in substantive law, substantive process. I think that the elimination of peremptories was really just a procedural change. It didn't change standards. It didn't change, again, prior decisional law in terms of the trial judge, deference given to the trial judge on credibility determinations. I think it obviously creates more onus on the trial court to manage voir dire. But I guess the state would differ, again, with my friend in terms of this creating a sea change in how voir dire takes place. And I think it's 3.5 years of decisional law since 2022 that supports that. Again, if you look at Colorado, Montoya, the majority in both Dobbins and Puga, Menez, Division 2, all of these cases in different facts, I think facts that maybe in some of those cases were more compelling than the facts in front of this court, have repeatedly said that the elimination of peremptories wasn't a sea change. It wasn't a radical overhaul.
And Arizona uses what is sometimes called the federal model for jury selection. It is limited, comparatively limited voir dire examination, but the parties have a voice in that if they choose to exercise that voice, correct?
Absolutely. And 18.5 really sets out, if you look at each provision, you sort of the totality, it really sets out a very holistic process for selecting a jury. Where the trial judge is running the show, but the parties absolutely have a place. And in fact, there's encouragement in, I think it's 18.5G, I'll find the word there, but the court is encouraged to allow the parties time for questioning and not limit.
It's F, yeah, you're right.
I think that was, some mitigation for the elimination of peremptories to say, hey, we're not completely cutting the parties out of this process. And in fact, Judge, trial court, make sure that, the parties have the opportunity to explore any answers that they're concerned about. So, unless the court has any other questions for me on either issue, I'm happy to cede my time and we'll defer to the briefing on the bribery issue.
Thank you.
Thank you.
I don't think anyone's ever invited me to talk more than I already do. That's on YouTube too. Okay. The answer to your question, Judge Dunley, it is there. Page 5, lines 15 through 19. The court did explained to the panel that if they wanted to have a conversation, they can have it.
That was my guess. Now, I get your points before about the nature of the environment, but thank you.
Sure. No, that's no problem. I should have known too, but it's there. And then I just heard my colleague, and again, I appreciate the professionalism and the amicability. It's sincere. I get that jurors might want to hedge. I think that was the word that she used. It's normal. It's a disconcerting is my word, but it's an unusual circumstance. But doesn't that kind of prove my point that if a juror candidate comes in and hedges, says, "I'm not sure,"
But in the context of, are you going to be biased against either side? If we're not, if it had been a little bit clearer, so you're saying you're opposed to drugs, and let's say the sister's not involved, and she said, "I'm not sure. I strongly dislike anything to do with drugs. I'm not sure I can be unbiased."
If the court's going to ask that question in the first place, which I would rather they had not done it that way, but if the court's going to go there, I think then the court has to ask it even-handedly, because if they say, would you be biased against the defendant or against the state, a juror might take that to mean, well, that judge kind of wants to be more fair to this person than that person. So I don't, to me, the vice in the question is not, it's the timing of it and the fact that it came on the heels of the only follow-up question, which was deflected by the juror. That's the vice with what happened.
But the first question you're okay with, is there anything about the fact that your sister's involved that may cause you to favor either side?
Sure, perfectly legitimate question.
So then it was just,
Had to be asked, actually.
but it was just the next one, if you were called to serve on a jury where those are the charges, would that in any way affect how you view the evidence? That's one where the juror interrupts and says, "No, I can be fair." And
Well,
sorry,
there was an intermediate question. There was a question that I have no problem with at all. Bottom of page 27, going to the top of 28. She says, "I'm not sure." Intervening question that she deflected, "Do you believe that her involvement may affect your ability to be fair and impartial?" She said, "I don't condone that." Yeah. And then the court immediately asked the yes or no question. "Well, let me ask you this. If you were called to serve, would that affect how you view the evidence?" And she interrupts and says, "No, I can be fair." And that's kind of circling back to one of the last things I said a moment ago, which is where in that very brief half page did she give anyone reason to feel good about her apparent reversal from "I'm not sure" to "I'm okay"? Because it's not evident from that. In fact, if anything, her deflection suggests that she was looking to get out of answering any more questions because she didn't want to go there. Not that she was okay and going to be fair. And then I'd like to...
We'll give you 30 seconds to
Okay.
give us a summation.
Sure. I can't agree with the argument that this isn't a sea change. I cited the United States Supreme Court decision of U.S. v. Martinez-Salazar. They talk all about the importance of peremptory challenges. It's a big deal. And for decades, it has commanded a lot of the criminal landscape on appeal. So I can't agree that this is more simply a pro forma change. And the last thing I'm going to say, I'll go to 60,000 feet. Seeing the forest for the trees, the golden rule they taught us all in kindergarten, if we had all been standing there in Raphael Morris's shoes and knowing at least some of the rules that we've talked about today, maybe not with legal parlance, but as citizens getting the general idea, and if we had seen this go down, knowing that the judge was the first and last line of defense, would we have felt really okay with that juror sitting on the panel of 12 with who knows what influence back in the jury room? We're not supposed to know. And then, as a result, 18 years in prison. I'm not sure that's the system we want, and more importantly, I don't think that's what the Supreme Court envisioned when they took away peremptory strikes.
All right, thank you.
Thank you.
Thank you both for your argument, for your briefing. We appreciate it. We will take this matter under advisement and issue a decision in due course. And with that, we are adjourned.